Welcome to the May edition of This Month in Payroll for 2024. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory and Operations Practice, and it's Budget Month. This month we will focus on the federal and state budgets, and we'll also review a few recent Fair Work Commission decisions affecting minimum wage rates, the 200% penalty in the GRIA, and the same job, same pay legislation. First, the budgets. So this month we saw 4 budgets handed down: Victoria, WA, Northern Territory, and the federal budget. The items of note from a payroll perspective varied from minimal impact in WA and the Northern Territory to more notable in Victoria. There were no great surprises in the federal budget, as the changes at a personal level had all been previously announced or legislated, including the introduction of Stage 3 tax cuts from 1 July 2024, the increase in superannuation guarantee rate from 11% to 11.5%, and the introduction of superannuation on Commonwealth government-funded paid parental leave for births and adoptions on or after the 1st of July 2025. After this date, eligible parents will now receive an additional payment based on the superannuation guarantee rate as a contribution to their existing superannuation fund. There was also nothing in the budget regarding payday super, which is still due to become effective on the 1st of July 2026. Although the government is providing $60 million over 4 years to support workplaces to implement policy changes such as the introduction of payday superannuation. At the moment, the Tax Office is consulting with the industry about payday super and also about ways that employee onboarding and choice of fund can be improved, working towards the release of legislation this year. The Victorian budget, on the other hand, included a few items of note from a payroll perspective. The first change was the announcement that the country's first pilot scheme providing paid sick leave to casual and contract workers would end in June 2024. The program was always designed to be a 2-year pilot program ending at this time. However, initial plans were that if the scheme was to be extended, any future ongoing scheme was to be funded by an industry levy. Its demise reflects the closing down of a number of COVID-era programs by the Victorian government. The second change was the repeal of Victoria's wage theft offence, following the introduction of federal wage theft legislation in the Closing Loopholes Bill. Inquiries to the Victorian Wage Inspectorate about pay rates, entitlements, awards and workplace agreements will now be referred to the Fair Work Ombudsman. However, the Wage Inspectorate will still be active in areas of child employment, owner-driver regulation, and an area of particular focus for Victoria, long service leave. The repeal of Victoria's wage theft legislation follows the Wage Inspectorate's decision to drop its criminal proceedings against the Macedon Lodge after the defendant asked the High Court last year to hear a constitutional challenge arguing that Victoria's wage theft laws conflicted with federal laws. The third change, including the Victorian budget, was to shut down its gig worker advisory service, again the first of its kind in Australia. This is done on the basis that the Closing Loopholes No. 2 bill will now provide new minimum rights and protections for gig workers, diminishing the need for an additional Victorian service. Both of these repeals reflect the extent of the federal government's workplace reform and are welcome repeals as they reduce the instances of employers having to deal with multiple jurisdictions addressing the same issues. Fair Work Commission cases. The Fair Work Commission has handed down a few noteworthy decisions over the last month, affecting minimum wage rates, general retail industry award penalties, and the same job, same pay legislation. First of all, minimum wage rates. A FWC full bench this month made a provisional ruling ensuring that the lowest pay classification in modern awards will be the C13 classification rate under the manufacturing award, $23.23 per hour or $882.80 per week. Any rates below that, for example the C14 classification rate, must be used as an entry-level rate that applies for no more than 6 months and must provide a clear transition to the C13 rate or higher. The Commission then went on to consider the application of this view to another 70 of the 121 modern awards that it had identified as containing classifications that are currently paid below the C13 rate. The Commission has proposed changes to 50 of those awards to include increases to the lowest pay rates and to clarify the transitional nature of any rates below the C13 level. These changes will be effective from 1 January 2025, although there will be a submissions period to comment on the proposed variations. Employers who are paying employees less than the C13 rate, $23.23 per hour or $82.80 per week, should watch out for the Commission's final decision regarding the proposed variations and be prepared to review rates and processes with effect from the 1st of January 2025. The second decision stemmed from an application from the Australian Retailers Association to vary the wording of the 200% penalty rate clause in the General Retail Industry Award 2020. The ARA contended that the provisions at 16.6 of the award's break clauses are currently ambiguous because they stipulate that employees should receive 200% of the rate that they would be entitled to for any hours worked where there is not a 12-hour break between finishing one day and starting the next. The ARA argued that this should be interpreted as being 200% of the award's applicable minimum hourly rate. However, the SDA, in response, has argued that the 200% rate includes 200% of any loading or penalty rates payable for the hours worked. In the right circumstances, this could result in penalty rates of up to 500% being paid for work performed during a break period. After considering the competing arguments, the Commission affirmed the ambiguity of the clause, noting that both interpretations were reasonably arguable, but that the SDA's argument could produce absurdly high outcomes. Accordingly, to resolve this matter, the Commission has varied Clause 16.6b so that it now provides for payment of 200% of the employee's minimum hourly rate, instead of 200% of the rate they would be entitled to. One issue that does remain after the ruling is that the variation is only effective from the 14th of May 2024, rather than being retrospective. There is, therefore, still some lingering uncertainty about the meaning of the pre-14 May 2024 provision, which could have an impact on some employers' historical compliance. The third area the Fair Work Commission has been asked to rule on revolves around same job, same pay legislation. The MEU has made two submissions to the Fair Work Commission over the last few months. The first on behalf of WorkPack employees at Batchfire Resources Callide Mine, and the second on behalf of employees of Programmed working at TESA's Mount Pleasant coal mine. In addition, Whitehaven Coal made a submission that employees of BP Operation Services working on the newly acquired Daunia and Blackwater mines should be transferred onto the relevant enterprise agreements because they are performing substantially the same types of work as Whitehaven employees. The FWC has been tasked with developing guidelines regarding these same job, same pay applications, and last month, following the Mount Pleasant submission, announced that it was considering whether to provide a generous opportunity for organisations with a broader interest in same job, same pay test cases to participate in these cases, to enable it to hear from a wide range of interests as to what sort of matters might be put into those guidelines. While the ACTU stated they were a little bit nervous about attempting to use these proceedings as a vehicle to substitute any consultative procedures that the FWC might otherwise engage in, it looks like we will need to wait a little longer before seeing a test case unfold. Word came down this month that the MEU's application on behalf of the workers operating at Batchfire Resources Callide Mine would not be opposed by the parties involved, and so would not proceed to the tribunal to be heard. In addition, the Whitehaven Coal submission has passed through unopposed, with Whitehaven noting that there is significant public interest in aligning the employees' terms and conditions at the two mine sites. At this time, the Mount Pleasant submission is still outstanding, so we will continue to monitor developments in both this case and the development of the Fair Work Commission's guidelines into what same job, same pay is actually going to mean. Before we wrap up this edition of TMIP, a flyover of a few other developments that came up this month. We start with the news that New South Wales Health settled this month the largest Australian wage underpayment class action settlement ever, $230 million. The settlement was for a class action initiated in 2020, alleging that New South Wales Health underpaid 20,000 junior doctors between December 2014 and December 2020 by failing to pay unpaid rostered and unrostered overtime, meal breaks and superannuation. There were a number of tasks that drove these entitlements, such as arriving early to prepare for ward rounds or staying back to treat an emergency patient after a doctor's shift has finished. Over 60% of the respondents reported differences between their rosters and the hours that they were expected to work. Similar claims are also in process in Victoria and the ACT, and we now wait to see whether there is an upturn in similar actions taking around payroll underpayments in this industry. Secondly, it was reported this month that Westpac will require salaried workers earning up to $140,000 a year to fill out timesheets. The move is designed to ensure staff receive the right entitlements, help protect Westpac from underpayments from employees working excessive unreported hours, address concerns that large amounts of unpaid overtime means that the employee's pay risks dipping below the minimum hourly rates, and to provide Westpac with a clearer picture of how and when employees work. This is also part of a broader governance focus, driven by the Fair Work Ombudsman and reflected in the recent IAG enforceable undertaking, which required IAG to commit to regular reporting to the board on the implementation of a new time and attendance system and compliance monitoring. The move to timesheets is also a move that is reported as being replicated or considered by other employers in the finance and professional services industries. Another benefit of the move to timesheeting may also come in the form of employee wellness. We are still waiting on the decision in the Financial Services Union test case against National Australia Bank on excessive hours, which is expected to define what counts as reasonable additional hours for white-collar salaried staff. And finally, we spoke a few months ago about the proposed introduction of a federal portable long service leave program for insecure workers. This legislation was deferred following feedback from the business community about the amount of change happening. However, last month, in a move aimed to attract and incentivise workers to remain in the community care sector, the New South Wales State Government released a draft bill introducing portable long service leave for workers in this sector. A public consultation period was opened up, and the government is working to a likely commencement date around mid-2025. If implemented as proposed, the benefit will be administered by the New South Wales Long Service Corporation, which already manages portable schemes for the building and contract cleaning industries, and it will be funded by an employer levy. The amount of the levy is yet to be determined, but is expected to be around 1.7% of the ordinary wages of eligible workers. This scheme would bring New South Wales into line with Victoria, Queensland and the ACT, which already have similar arrangements in place for community care workers. It is estimated that 230,000 workers, of which 75% are women, are currently employed in this industry. Historically, these workers haven't been eligible for long service leave due to the high rate of changes between employers or parts of the sector. So, in a sector where demand is expected to double by 2050, this initiative is intended to attract and retain workers. And that's it for our May edition of This Month in Payroll. If you would like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll.